a good lesson for your audience if you're in the capital raising space or in the syndication space. I mean, putting yourself out there as a thought leader, especially on the channels where your avatars, which are your limited partners if you're a sponsor or an operator, where are they? Are they on LinkedIn? Are they on Instagram? Like, are they on YouTube? I mean, you got to figure out your particular avatar.
The Apartment Gurus podcast is brought to you by Greenlight Equity Group, an apartment acquisitions and holdings firm co-founded by Carl York and Tate Siemer, host of this show. We offer you the opportunity to be an owner of cash-flowing, wealth-growing apartments without the headaches of being a landlord. These assets are recession-resistant, risk-mitigated, offer significant tax advantages, and are a great alternative to the stock market. Ready to check it out? Go to www.investwithgreenlight.com today to book a personal consultation with Carl or Tate. Again, that's investwithgreenlight.com. We look forward to meeting you. Welcome to The Apartment Gurus, where twice a week, host Tate Siemer brings you deep dive interviews with the wisest gurus in the apartment investing industry. These experts are sure to create game-changing value and inspiration designed to catapult your business to the next level. Be sure to reach out to Tate at www.investwithgreenlight.com for access to his investor portal and Calendly link. And now, here is Tate Siemer and the Apartment Gurus.
Welcome everybody back. Another episode of the Apartment Gurus, and once again we are putting the guru in the episode today. Delivering on the podcast name, we've got legal guru, and I think it's very fair to call you that, Mauricio Rauld. You have produced so much content in a way that is just always value add, right? Like, so, for listeners right off the bat, go to Mauricio's YouTube channel, Mauricio Rauld, Rauld. Do the YouTube search bar there for him, and you will find a wealth of legal tips, things to watch out for, things to be proactive about, things to put in your business, things to make sure you're doing with investors and deals and the SEC. And basically, Mauricio's mission is to keep us out of trouble, essentially, right? Would you say that's my tagline? I keep real estate syndicators out of jail. There you go. Right. That is massively important, like of huge importance. So really appreciate you being on the show, Mauricio. This is, we've worked with you. We've worked with Premier Law Group, your company, and we'll talk a little bit about that and kind of some unique things that you guys do, as well. But, thanks for being here, man.
No, thanks for having me. It's super. Yeah. Thanks for having me. Super excited to be on.
Yeah, you bet. Mauricio, for listeners that aren't familiar with you, have not run across you on the socials, which is, you're hard to miss: LinkedIn, Facebook, and then of course YouTube. Tell us a little bit about you, kind of your backstory. You hang out in the SoCal area, but yeah, tell listeners a little bit about you and kind of how you got to where you are and what you're doing today.
Yeah. So as you said, I am an attorney, but don't hold that against me. My good friend, Tom Wheelwright, likes to say I'm one of the few lawyers that actually speaks English. So my superpower, and I've come to accept it, but my superpower is really taking complex legal matters and just make them easy to understand and distill them in an easy format. And as you mentioned before, I put out a lot of content. I come from the Gary Vaynerchuk, Gary V school of Knox, and it's just add value. I think at some point there's supposed to be a right hook in there somewhere, but that's the part I forget. I just keep jabbing and jabbing and jabbing. But I love it. It's one of the things that really lights me up is to teach folks, whether it's primarily obviously the legal part. I mean, I've been doing this, as I said, for 25 years. So started practicing in 1999. So yeah, literally 25 years ago now. I went to school here in California, went to UC Berkeley, law school at Loyola. And then I did what most lawyers dream of doing, which is I went to work for a big law firm here in SoCal in Long Beach, and I did litigation. So I was the one that was doing court appearances and depositions and motions and, all that kind of stuff. And I was a defense attorney for both securities firms. So I did represent sort of the JP Morgans, Merrill Lynch's of the world, American Express of the world. And because we're here down at the port, I also did a little bit of, or a lot of maritime work as well, but it was all on the defense litigation side, right? So I did that for a while and then just realized that that's not really, just something seemed off, right? You get up, I literally think about the lawyer world. I get up in the super early, I just get dressed, get in the car, go drive, go to work all day, work all night, come home, track my time 6-minute increments, which is not something I would suggest, but everything I had to do was literally document every 6 minutes of time, which drove me crazy. And I had the great fortune of coming across the Little Purple Book about 5 years into my practice, Rich Dad, Poor Dad, which I know a lot of your listeners, if not, man, if you haven't read Rich Dad, Poor Dad by this point, I'm not sure, I don't know what you're doing, but
so at some point I'm going to have my EA like go through every episode and listen to everybody's backstory and see what percentage literally Rich Dad, Poor Dad comes up in. And I'm not even like, if you're watching the video, I'm not even smiling. Like, it is legit the most influential real estate and I may arguably with business finance, book out there. And in terms of like changing people's trajectory completely, and especially in the spaces that we play in.
Yeah, and it's not, and just to be clear too, a lot of people, I think some people I've seen it said that disappointing because there's not much content in there. It's really more of a mindset, and that's really what affected me because it sort of confirmed that what I was doing back then wasn't what I wanted to be doing when I was 65 years old. Like, I mean, I literally go into the office on a weekend because as lawyers you do, because you've got to bill your hours, and if you're short, you got to make them up. So I'd go up on a Sunday morning, for example, and I would check in, it's the weekend, so security is checking you in, and I would see everybody who's checked in before me. I'd go show up at, 11 or 12 o'clock, and I would see partners that have been working at the firm for 20 years, had kids and have a family, and I know they're family men, and yet they're coming in on a Sunday to grind at work. And I'm like, I just didn't want to do that. I was at least aware enough that that's not what I wanted to do. So Rich Dad Poor Dad really changed my mindset. And as a result of reading that book, this is really serendipity. I mean, literally the week after I read that book, I read it on a flight back from Miami, like an all-in-one, just gobbled it up as probably most people did. But literally the week after, I was driving down in LA and I heard a drop in. It's what's called a radio. Back then it was radio. That's how long ago it was. Right? So there was a radio drop.
I was going to, do you mind like a year approximate?
This would have been like 2004. So I think the book had been out for a little bit. It probably had just caught fire, I'm guessing. I almost didn't even buy the book because back then I really disliked books with the word rich in them. So Rich Dad, Poor Dad, or How to Get Rich, or Rich This or Rich That. I really didn't like it. But it had the #1 bestseller in New York Times sticker on it. So I was like, all right, I'll get it anyway. And so I'm driving down. I hear Robert Kiyosaki with a drop in for the Real Estate Guys. I don't know if you guys are familiar with the Real Estate Guys. Been on the radio now for, I think, since 1997 or something. And I've memorized. It's such a pivotal moment for me. But basically, Robert came on the radio and said, hey, this is Robert Kiyosaki, author of Rich Dad, Poor Dad. If you're serious about investing in real estate, check out the Real Estate Guys. They really know what they're talking about. And I was interested in real estate. Had I not read the book, that radio drop in would have been meaningless. Like, I don't know who Robert Kiyosaki is. It would have been nothing. But because I'd just been blown away, that really resonated. They were putting on some event down here in SoCal. I went to visit it, blew it away. Long story short, I ended up leaving the firm because I knew something was off, and went and worked and became general counsel for the Real Estate Guys. Thanks to that drop in, thanks for me attending that event. And then Russell Gray, one of the co-hosts, approaching me about maybe joining them to help them with legal. So that's how I kind of got out of the world of the law firm world, which, can easily be golden handcuffs. Most people would love to leave the law firm world, but they've got now making, good amount of money. They've got a mortgage, they've got a car payment. They just can't get out of it. So I was fortunate enough to be able to get out, went to work for the Real Estate Guys, became their general counsel. And that's really where I cut my teeth on the syndication world. So I'd done securities work before, but it was all defense litigation, defending, like I said, these big securities firms. And so while I was working for the Real Estate Guys, they were raising a ton of money. Again, back in 05, 06 now, old school, right? Like in person, suit and tie. They had just switched over to PowerPoint. They were doing acetates or whatever the thing before. That's how old it was. And people would show up to these events with their checkbooks. And I was there with the documents, all the private placement memorandums printed out. People would physically sign, write a check. I mean, it was really, really old school. But that's really where I cut my teeth in the syndication world. And after a couple of years, I sort of decided to kind of start my own law firm, Premier Law Group, which I officially started in 2006, but really implemented it about 07, 08. And, kept the Real Estate Guys as kind of my VIP clients, but it really was where I made the transition And, at the beginning, you just basically take on whatever you can that puts food on the table. But eventually it kind of narrowed down to just doing securities work and asset protection. I just spent a lot of time doing entity formations, asset protection, which I consider myself one of the foremost experts. In fact, I wrote a book about it. But I just realized at some point that most of my revenue was coming from syndications, and I made the decision to just go all in on syndications. This is right around when my daughter was born. So this is about 8 years ago now. And since then, I've never looked back. That's all we do right now is real estate syndications. We help real estate syndicators make sure that when they raise capital, they're doing it in full compliance with federal and state securities laws, and that's what we do today.
Yeah, yeah, and you do it. You do it, first of all, very well as a client, and somebody that has a front row seat to kind of how you guys do things. And one of the unique things, just again from the client side and us as syndicator side, that I really appreciate about your model is, and I should have maybe asked if this is still the case, and there haven't been any significant changes. But essentially, when we do a deal with you, Mauricio, there's no surprises in terms of big, huge expenses because of the way that you essentially structure things, and that is so not the case in this world. I mean, the ability for a lender's legal, for instance, we're in an acquisition right now where we've fronted the lender a $50,000 expense deposit, basically, that they are now through, and they're asking for another 30,000, and it's essentially they're legal, right? And it's like that. It's just the insanity of that, and like the lack of like disclosure there, and that was even coming and whatnot. You guys do things so differently. You want to talk about that a little bit?
Yeah, I mean, just in that scenario, it's almost like where the government does it. It's like the incentive structure is so perverse in there because they have no incentive to do things. The lender, in your case, has no incentive to do things efficiently or well or doing it perfectly because they just know they've got you by the what. I mean, they need more money. They're going to ask for it because they're the ones giving you a loan. Yeah, we've done. We do a flat fee. So we, like to your point, we don't want any surprises. We want you to be able to put your expense in your underwriting and say, hey, it's going to cost 15 grand or 20 grand or 13, whatever the number is that we prearranged ahead of time. And that gives you certainty. Like there's for us, it's unlimited attorney time. There's no nickel and diming. It is what it is. So at least on that front, you're not going to have any surprises. The surprises might come from the lender. Sometimes the real estate attorney, which we are not, by the way, we're not real estate counsel. That's a separate attorney, separate transaction. They'll charge by the hour. So depending on how complicated things are, how much pushback you get from the lenders, that might be a little bit. But for us, we've been doing for so long. I mean, we do a couple hundred of these every single year. So we know how long it takes us on average. And so we've just come up with a flat fee model, and that's what we charge. And we really have focused on, so I appreciate you making those words. We really have focused on the customer experience because that's the thing I feel like a lot of other firms just don't get. So for me, anytime I get a client coming in from another firm, I can always guess it's one of two things, one of two reasons they're reaching out for me. Number one is the turnaround speed is just taking way too long to get the documentation for their investors, or it's just taking too long to respond to a phone call or an email, which it happens to me with my lawyers and my accountants. It drives me crazy. Yep. So fast turnaround, and then access to lawyers is the other one. Like they just, you just can't get a hold of the lawyers. They email, they got to follow up 3 days. So those are really the two things that we really focus because we are customer obsessed, and we want to make sure that, the customer has an amazing experience so that they want to come back. As any business owner, you want to have the customer be super happy. They want to come back. I want them to tell their friends. And so we really focus on the customer journey and the customer experience to maximize that.
I was thinking as you were describing that, and the incredible value that you place on the customer experience and customer journey. For me, what it tied into is your thought leadership in this space. The fact that you stand on a stage at, say, Best Ever Conference, and you got 1,200 people listening to you, and you've got a YouTube channel with thousands of subscribers and hundreds of views per channel or per video, right? Like you can't, and you're doing it all the time. And by the way, I love Gary Vee. I just think he's just a gem, and
he is.
What a gift he is to entrepreneurs. But his approach, his philosophy, and basically, sorry, I lost my train of thought there. Well, I'll come back and pull that out too. But
No, but Gary,
Oh, I know
great.
what I know. What I was
Yeah.
gonna say. Yeah. So just the fact that you put yourself out there, quite frankly, and when you do that in volume all the time with consistency, and people see you, and they become you become somebody that they feel like they really know, right? You're also like, at that point, you got to deliver on that branding that you've created, on the messaging you've created, on the value set you're putting out there, right? All that stuff. Like it's almost like this space of podcasting, in your case, being a guest on a zillion podcasts and having this robust channel and doing your own videos, and like that demands like a different level of authenticity, and but also execution, and like, you're out there, you're on stage, right?
Yeah, I do a lot of stages, a lot of podcasts, my own video. I wish I still plan on actually doing more sort of one-off videos for my channel. But this is a good lesson, I think, for your audience or anybody who's really, especially if you're in the capital raising space or in the syndication space. I mean, putting yourself out there as a thought leader, especially on the channels where your avatars, which are, your limited partners, if you're a sponsor or an operator, where do they congregate? Are they on LinkedIn? Are they on Instagram? Like, are they on YouTube? I mean, you got to figure out your particular avatar. But for you to be in front of them and reach the scale that you can reach when you just put out a video, or just even if you're not super comfortable in video, maybe it's just a photo with some copy. I mean, there's a lot of great, there's a couple of CPAs that I follow on LinkedIn, and they don't usually put any videos, but it's almost pure text, but there's so much value. It's almost like a newsletter every day, but you read these posts and you get so much value. If you can then have them make the connection between that value and you, then they're going to start knowing, liking, and trusting you as an operator. Then when it comes time to raise capital and you're talking to them on the phone, it's not the first time they've heard of you. They've been following you. They've learned a lot from you. They know you're an expert in the field. And I think it just helps out a lot for in really whatever industry you're in, but especially on the syndication, and in my case, the legal as well.
Right. Yeah. And legal's a trust position. Well, these are all trust positions, right? Obviously, if somebody's investing 100,000 or 500,000 or 3 million or 10 million with you, that's trust, right? Of course. But just like anything else, there's a lot of Mauricio has a lot of competitors out there, and so like just to stand out and to win business, right? That trust, trust, but I think especially trust with legal has to be there, and it's pretty dang easy to get on like a YouTube channel, or ideally somebody's LinkedIn profile you could establish this too, and just find out kind of how they do things and at what level they do things, and what do they care about? What are they paying attention to? What are they talking about that's important to them? And how are they adding value ultimately at the end of the day? I think it's important. One thing before we go much further, you made a distinction about 5 minutes ago or so between a real estate attorney and a securities attorney. And I think it's important for listeners to understand that, with us at Greenlight Equity Group, we have a group out of Columbus, or they do our work in Columbus, but they're in Cleveland, and they are basically they handle our contracts, right? They handle in some cases negotiations and addendums and due diligence items, right? Like pretty much they handle kind of the whole kit and caboodle, except for this incredibly important piece, which is like entity formation and org charts and your private placement memorandum and your operating agreements, right? And those are the things that have to be tack sharp, with every I dotted, every T crossed, because those are that's the legal mechanism inside of your deal and your syndication for your investors. And they have very robust set of protections per the SEC. You're essentially selling a security. And actually, I'd love for you to just kind of break that down, right? Like we're essentially security brokers operating within an exemption that the SEC has provided, right? I mean,
when you're raising, anytime you're raising money from past investors where the returns are generated by your efforts, meaning you're doing all the work and the investor's just writing you a check and going home and relying on you to give them the return, that's a security, which means you are in the business of issuing securities to your investors, which is why the SEC or the Securities and Exchange Commission is even involved. Because a lot of folks, especially who are just starting out, they're like, well, why is the SEC involved? I mean, I'm just buying a piece of property. Like even some people put together small deals for single families or duplexes or what have you, and they don't realize that the definition of a security is extremely broad. I mean, it's not just what you think of stocks or bonds or LLCs.
Right.
But the structure doesn't actually matter. That's, I think, the biggest takeaway, especially if you're just starting out, or even if you're doing this for a while. I think it's one of the biggest mistakes that I hear syndicators make is how you structure your deal does not matter. Like you could do it as a loan, you could structure it as a tenants in common agreement, you could structure it as a profit share, a side contract. The structure itself doesn't matter. If you are taking money from investors where the returns are generated by your efforts, you are in the business of issuing securities to them, and you are then bound by all the regulatory nonsense, as I like to call it. And that's what we got to follow. And generally speaking, the main regulation requires you to either register that security with the SEC, which you never want to do, or find an exemption to the registration. Or as I like to point out, number 3, it's illegal. Those are your options, right? And so most people have heard of the exemptions of 506B, 506C, Reg D, Reg A, although those are just the exemptions to registration so that you don't actually have to go and do that registration, because the registration process is extremely onerous. It's basically going public. So imagine having to go take your syndication company public. And I mean, it's just, you didn't even have time. I mean, you're in the middle of one right now, Tate. You don't have a year and a half to get this thing through the SEC for approval. You got to close in 60 days or 30 days or whatever it is. So anyway, so that's one of the main regulatory bodies, which is all from the Securities Act and the exemption, because the Securities Act requires you to either register or find an exemption. So my job is to figure out what's the best exemption for you. And then let's make sure we execute and follow the rules so that we are exempt, because if we don't follow the rules and we're not exempt, then what I have is an unregistered offering, which is problematic.
Yeah. No doubt. Or if you, go ahead.
I would say just to kind of, I wanted to piggyback on something else you said right before that question, which is the different lawyers. And so lawyers are no different than doctors, right? If you go to a cardiologist, for example, they're an expert in the heart, right? So if you have a heart problem, you're going to go see a cardiologist. But if you suddenly, tweak your ankle or you've got your knee busted and you need help, you could go to a cardiologist, and they may have some idea, but really what you need is an orthopedic or an orthopedist. So it's the same thing with lawyers. Like I specialize in security. I'm an SEC attorney. I focus on making sure people follow the securities laws. A real estate attorney or a transactional attorney is somebody who makes sure that the transactional piece, the purchase and sale agreement, the lenders pulling title, all the reports. You have estate planning attorneys that make sure that when you pass away, that your assets are done a certain way. There's insurance attorneys that specialize in making sure insurance policy. I mean, there's so many different types of attorneys, just like there's all types of medical doctors. And so you just got to make sure that you're using the appropriate ones, because one of the mistakes I see people make is using a securities attorney to help them with the purchase and sale agreement or having the purchase and sale agreement. That's where you get into trouble, because they're not experts in that field, just like a cardiologist would not be the best person to go see if you busted your knee.
Yeah. I mean, again, we're talking about staying out of jail, right? And so, and that's like real. It's not hyperbole. And so to have the specialist, the best specialist that you can get access to, reasonably, right, on your team to make sure that you stay out of jail is like incredibly important here. And it's not hard to inadvertently not do something that's required by law, and I'm not necessarily saying that from experience of having done it. But who knows? The honest truth is, like, these PPMs are 60, 80 pages, 40, 50, whatever pages long in some cases. And every word matters, right? Even though it's like legalese to a lot of us, every word matters. And so you got to get this right. And so use the analogy of, like, if you bust your knee, not going to a cardiologist. I think, like, even to bring that down a little to more reality, like, I think a lot of people think, well, I've got this great attorney that I've got this history with, and they've handled my single family stuff. And anytime I need something, I go to them. And look, if you've got somebody like that says, we can handle your SEC work, I've done some of that in the past. No, in my opinion, no, that could be a wonderful attorney and a wonderful relationship that you want to keep using. But, like, this truly is a specialist requirement in my view. And you want to have the best of the best.
I'm even more. Yeah, and we're even more specialized because we only do real estate syndication. So I'm like, if somebody comes to me and says, I want to raise money to go buy a business or to go, start a marijuana, distillery or something, it's like we will refer
Oil
that
and
out.
gas, data center,
Oil and gas. Yeah.
Yeah.
So all we do, because that's what we feel we're experts in, is the real estate syndication. So we only represent real estate investors, real estate syndicators who are raising money for real estate projects.
Yeah, it's an excellent point. And that's just one other thing to mention is that, you can syndicate just about anything, right? You can syndicate a lemonade stand. Like, but if you're syndicating, you need to be, using the exemption or registering the security or whatever it is. So, I mean, just to kind of really get into the, I think the important value points here. I want to ask you, first of all, about the LLC law, that we all need to be aware of coming up here at the end of the year. We have a deadline that's important. And actually, why don't we go ahead and let's just unpack that one here real quick, Mauricio, because everybody listening needs to know about this and all of their friends need to know about it.
Yeah, so there's a new law that became effective January of this year that that actually requires anyone who has an entity, that for us, it's usually LLCs, but it's any entity. So it's a limited partnership or a corporation or an S corp or whatever it is. It requires you to disclose certain information to the government through one of the government agencies called FinCEN. It's a financial crimes enforcement network. And so if you have
FINCEN.
FINCEN. FINCEN. So just Google FinCEN and you'll see. And so the rule is it depends on when your entities were set up. So if you've got some legacy, which obviously is real estate investors, you've got entities that you set up last year or the year before or 20 years ago, whenever you bought that first rental property, all of your prior LLCs, you have a deadline till the end of this year. So we're about 2 months out now to file all this information. And it's actually a double information. One is for the company itself, and then one is for the beneficial owners, which are the individuals, the ultimate individuals. And it's kind of basic information, but it's for some and for me that are really big on privacy, it feels very encroaching because you have to provide them not only your name. So for example, on the individual side, let's go through the individual side. I've got to provide my name, my home address, not my office, not my PO box. I've got to give you my driver's license, some kind of identifying number, usually a driver's license or a passport number or some official government license number. I have to give you a copy of that number. So if I'm giving you my license number, I've got to upload a copy of my driver's license or a copy of my passport. Wow. And that all has to go to this governmental agency, which theoretically anyway, for now, it's really limited to the governmental agencies. So it's only used for the FBI, the law enforcement, the tax folks, the IRS. Those people will have access to that information because the whole purpose of this, at least allegedly, the purpose of this is to avoid people who are doing tax evading or doing money laundering or these nefarious activities. The government wants transparency of those things. So if you've created an entity prior to 2024, you have until the end of the year to file this requirement. So it's coming up, and I've got clients that have over 100 entities. So imagine having to file over 100 of these things to disclose this. If you file something this year, so if you filed anything as of January 1st of this year, you actually only had 90 days to get that filing. So the end of the year is only for the ones prior to this year. But if you filed something today, well, today actually you would technically have actually a little bit more than 90 days. You have 90 days. Now, originally it was 30 days. So when the rule came out, you had 30 days from the time you set up your LLC to provide all this information. They extended it to 90 just because it was a shit show, to be honest with you. But starting next year, unless they amend it again, it's going to go back to just 30 days. So if you file something next year, you basically have 30 days to get this information. And then if you change the information, right? So if you, for example, set up an LLC and then suddenly add another member or add another manager or add another beneficial owner, then you have 30 days to file an amendment to that because there's really no way around this. And so, it applies to anybody who's a beneficial owner of your LLC, which means anybody who owns more than 25% ownership or has substantial control over the LLC. So you don't even have to be the owner. Like people sometimes set up LLCs and they're not technically on the records. They may not even be the manager, but if you're in the background pulling the strings because you have some kind of a contractual relationship where you make all the decisions, that's gonna catch you in this net. It's a very, very wide and broad net. There was actually just as I'm saying this, Nate, Tate, there was a in Alabama, I believe it was, there was I forget the name of it now, but there's this group of investors that actually sued the government in the federal court in Alabama. And the judge did find that the law was unconstitutional. It's called the Corporate Transparency Act. They actually found that in that particular case that it was unconstitutional. Now, unfortunately, that ruling only applies to the membership of that group, which I think about 30,000 investors or members in that group. So if you're part of that membership, great, you're exempt. But that'll go through the court system. It's going to get appealed. It has been already appealed. It'll go to the circuit court. And eventually, I wouldn't be surprised if it ends all the way up in the Supreme Court. But until it does, this is something that we all have to comply, and people are up in arms about it, as they should be. But it is right now a requirement. And you've got till the end of the year. You've got about what is it now? 75 days to go.
Yeah. As of today, we're recording this on October 16th. This will probably come out in the next couple of weeks, by November. So yeah, you basically have 2 months. What is the best way, Mauricio, for a listener to just make sure that they've, the CYA, right? Like, somebody that, let's say somebody's got 4, 5, 6 properties, with these syndications, we form 4 entities in a lot of cases, depending on the structure, right? So what are your thoughts on, well, let's just take me. I'm in 9 properties, 9 GPs, right? Each of those properties has their own LLC. I've got my holding company that holds my position in their LLCs. Actually, and a lot of these structures have, the managing entity, right? The LP entity, the GP entity. So you're forming multiple new entities in most cases. I think if you're doing a good job, you should be doing that every single time. So I'll just throw out a number. I'm probably in 25, 30 entities, right? So
yeah.
So what do I do?
Well, I would probably start with the spreadsheet and literally list out about 25 or 30. Now, the good news is that I know you're a sponsor, so most of these you probably do have to report. But the good news is if you're an investor, if you're a passive investor, and you're just a limited member or limited partner in one of these deals, it's unlikely that you are a beneficial owner because you probably own 2% or 1% or 3%. So you're definitely going to be under the 25% threshold, and you're a limited partner. So you have no control. Forget about substantial control. So if you're an LP in a deal, it's not something I would worry about. But if you're the GP in the deal, for sure. So if you own, if you're a sponsor in a syndication, then all of those issuer syndication entities, you would list those, your holding company, if you've got, your own real estate deals on the side and you've got single families or something in their LLC. I mean, you literally have to search, and maybe there's a way, depending on the problem is you probably set them up in all kinds of different states. So it's difficult to find, but you really should go back to your CPA is probably the best place and just make sure you have a list of every single LLC you have. Put them in a spreadsheet and then figure out, are you a 25% owner of any of these LLCs, or do you have substantial control over them? If the answer is yes, then it's time to go and get every single one of those things filed. Now, the good news is there is a little bit of a shortcut for folks like you because they at least thought of this, but you can actually get what's called a identifier number from FinCEN. So you do it once and you upload all your personal information. I forgot you also need to give them your date of birth, by the way. But once you upload all that personal information, the driver's license, you get all that, they can give you a number. And so then you can insert that number on every subsequent filing. So you don't have to keep uploading all this information every single time you do it. You just have this FinCEN identification number that you can use, but you're going to have to do it 25 times. I mean, you're going to have you or someone, and there's actually now a lot of outfits that are doing this where it's, I think, relatively inexpensive that they're charging, but I would probably go to an outfit like this and say, hey, I've got these 25 LLCs. Can you please, file these beneficial owner information things with FinCEN?
Yeah, gotcha. One last kind of in the weeds question on this. Let's say I'm a lead sponsor and I've got 3, 4 GPs inside of my LLC, right? What's my burden on producing information for them?
Yeah, that's a great point. So you do have that burden. You as the manager have that obligation to, and it's not only you as the manager, it's actually the filer as well. This is one of the reasons we at Premier Law Group no longer file entities without first getting all the information. Because if I file an entity for you, for example, and there's 4 of you, right? And I only get the information from you, Tate, and I can't, for some reason, the other 3 don't want, what if they don't want to give me the information? Like, well, then I'm on the hook. Like, it's my responsibility as the filer. It's my responsibility as the individual, which would be you. And then also it's your responsibility as the manager or the person who has substantial control of the entity to make that filing. And so it's your obligation to go get that information from everybody else. Now, you could argue that it wasn't, malicious and you didn't intentionally avoid it, but that's one of the issues that we are now writing into our operating agreements, is to sort of legally bind people to it's actually one of my recommendations, is to legally bind the other members in your LLC to provide that information. If they don't, to then indemnify you, because if the penalties are pretty obscene, it's like $500 a day per infraction.
Right.
So if you can't get a proper filing because your partner didn't want to give you their driver's license, like, I'm not going to give you my home address or whatever, then there's an issue there. And so having some kind of an indemnification provision where if you do get fined because of the act of somebody else, at least you have legal recourse against them, because otherwise there's that part is missing in the statute.
One last question on this one, and then I've got another real good one that you've talked about hours and hours and hours on this one. What do you know about like enforcement, and what's it like? Like obviously we have the burden of what we need to do, the burden of proof or whatever you want to call that. But for the unlucky ones that don't know about this, that for whatever reason don't get it done properly, like we talked about the risk, $500 a day. Probably
I mean, it's been a little bit early because it just literally has come out. Right. So I do know, I mean, ignorance of the law is never an excuse. So you not knowing about it is not going to be, it's not going to be a great excuse. Now, will they be a little bit more lenient if you suddenly didn't know about it? And so now you owe them, $10,000. Will they either waive the fee or do a discount? Maybe that's going to be on a one-on-one. I haven't really been paying attention too much as to the enforcement part, but I do know that ignorance of the law is not an excuse. I have 2 videos on my YouTube channel. So if this is something you're interested in, just go to my YouTube channel, type in Corporate Transparency Act. In fact, it's my favorite thumbnail I have. It's literally a big foot stepping over a little guy. The government is literally stepping on your thing. But I do the original video, and then I do talk about the update from the lawsuit that got upheld. And so there's 2 corporate transparency videos there if you want to check it out.
Got it. Speaking of your YouTube channel, I would recommend first of all, you just got to go see the entire scope of everything that's talked about. I mean, how to stay out of foreclosure, some really valuable, like essentially clinch things that could kind of save the day for you in a lot of cases, or keep you out of an otherwise big pitfall. But let's talk about how to get paid as a capital raiser in a syndication issue, Mauricio. And I maybe should have cleared this with you before we started recording to make sure that you're okay talking about it, because I'm sure it's the one that you have like probably 80% of your thought leadership time talking about, like how as a GP structure or as a GP that's raising capital, how to get paid on that. But it's so key, and it's something that so many people are not doing right. And so I feel like it'd be a disservice not to bring it up.
Yeah, I mean, I dedicated a whole chapter on how to pay capital raisers. I have that book, 5 Things Every Syndicator Must Know to Stay Out of Jail. And so I have a whole chapter on it. Just stayoutofjail.com.
Where do listeners get that? Amazon?
Stayoutofjail.com. Go to
stayoutofjail.com. There you go.
You can get it. It's a free book that I wrote, and I think chapter 4 or 5 of it, I forget which one, talks about the fact that so here's the thing with capital raisers. Just like you cannot practice medicine without a medical license, just like you can't practice law without a law license, you cannot be a capital raiser or raise capital without a broker-dealer license, not a real estate license, a SEC, actually FINRA broker-dealer license, or unless you find an exemption to that. So general rule is you need a license. If not, we need to find an exemption if you don't have a license, right? And so when you are a GP, right, a co-GP, right, coming in, you cannot just be there to raise capital for the syndication LLC, because that means you're raising capital for the syndication LLC and you don't have a license. The way you get, I don't want to say you get around it, but the way you get exempted from that is something called the issuer exemption. That's the one that this is the one you rely on. Tate, this is the fun part, is that, and this is where I think a lot of people undervalue their securities attorney. You and I probably never spoke about this during our representation, but that doesn't mean it's not there. It doesn't mean that the attorney isn't thinking through the process in the background. So this is one of the things that would come up. Like, I know, Tate, because you are the lead sponsor, you and your partners through your company, you are doing all of the work. You are doing substantial work. You are doing the whole syndication, right? So you not automatic, but you fit into this thing called the issue exemption, because in order to fit into the issue exemption, you have to be doing what's called substantial duties in the syndication. Now, of course, you guys are doing all the duties, so forget about substantial. You guys are doing all of it. You cannot take transaction-based compensation. I mean, I can't be depending on how much money I raise will dictate how much money I'm getting paid. You're getting paid for all the work you're doing. You're doing the due diligence, the pro formas, the underwriting, the actual operations, all of it, right? And then the third one is your primary role in the deal, in the syndication, has to be doing those substantial duties. So 3 things: no transaction-based compensation, you have to be doing substantial duties, and then your primary role has to be doing those substantial duties. If you fit all 3, then you're a part of this issuer exemption, which is what most syndications are. But what's happening?
Real quick on that,
yeah.
transaction. Does that that sounds like an acquisition fee, largely,
No,
but it's not.
Well,
That's not tied directly to how much.
That's right. So one of the mistakes, So one of the mistakes some syndicators make is they will tie the acquisition fee to the amount of money they raise.
Got it.
That's not something I would do. So you can charge an acquisition fee based on the value of the property, of the purchase price, or the acquisition of that, because that is a legitimate fee. I mean, in order to acquire that property, you're doing a crap load of work. I mean, I just described most of it. You're doing the underwriting, you're doing the due diligence, you're doing the market research, you're getting the loan, you're doing all this work. And so charging a 2% acquisition fee to acquire the asset is pretty standard. What I wouldn't do is charge 2%. Hey, I raised $2 million, and so I'm going to charge 2% of the $2 million, and that's what I'm going to get charged, because that starts to look more like I'm getting paid based on the actual raise. But when you bring in a person that's just here to raise capital for the co-sponsorship part, then they don't fit into the issuer exemption, right? Because number one, they are getting paid transaction based, meaning, hey, if I bring in 500 grand, I'm going to get 5% of the GP. If I bring in $1 million, I'll get paid 10% of the GP. If I don't bring any money in, I won't get any money. That's all tied to how much money I bring in. So they fail that part. The second part they usually fail is they're not doing anything. They're not doing substantial duties. Like, what are they doing? If they're just bringing in the money, then they're not satisfying the substantial duty piece of it. And then the last part is, what is their primary role? Their primary role is bringing the money, so that they violate the third one. So because of all those issues with the co-GP, you don't fit into the issuer exemption, and therefore you need a broker-dealer license. And of course, nobody has a license out there that's being a co-GP. So if you are going to be bringing in capital, by the way, there's nothing wrong with partnering with somebody and then having access to their database and their investors, and then bringing capital into the deal. That's part of the package, right? As a syndicator, one of your duties as a syndicator, is to bring in the capital, right? But that's just one of, we could probably put a list together, the 50 things you do. So when you do have somebody else coming in that's not already part of your company and you're kind of partnering with them, first and foremost, make sure that they're adding value to your syndication and they're performing substantial duties. Now, I agree that's a very nebulous term. It's difficult to nail down what exactly is substantial. Is this enough? It's very facts and circumstances. So what I generally do is I want to listen to all the facts. What are all the things that the team's doing? What are you doing? How much money are you raising? Kind of like figuring all that stuff out. But so make sure that you're doing substantial duties, that you primarily are doing those duties, meaning once the deal closes, right? What are you doing? Because a lot of people will raise capital as co-GPs, the deal closes and they're gone. Like, they're not even around anymore because their primary role was to bring in the money. So what part of the asset management are you doing? Are you whatever? What are you, boots on the ground? Are you doing the property management meetings? Are you putting the plans together? Are you doing the reporting? Like, what are you doing after the deal closes? And then again, no transaction-based compensation is the hallmark of broker-dealer. Because anytime you're getting paid based on how much capital you bring into a deal, you're going to be dead in the water.
Yeah. Okay. That's the key. The firms that you work with that are doing this right, how do they do it? It seems pretty basic. You just laid it out. It's pretty dang simple, and there's some pretty basic requirements. But
I'll tell you what they're not doing. They're not having 17 co-sponsors. Let's start with that, right? Usually, look, you guys are a company. Usually, you don't need more than the team that you have. Maybe you bring in another person because they are, maybe you're expanding to another market, for example. So let's say you said, hey, I really like Florida. I don't know why, but let's say, hey, Florida's in trouble right now. I think there's a lot of opportunity in Florida, but you're not in Florida. You don't have a team down there. So partnering with somebody who's boots on the ground, who knows the Florida market really well, that makes sense. So bring them in to be boots on the ground. Or maybe you're switching asset classes and you're like, hey, I'm going to go into self-storage. I've never done a self-storage deal before. I'm not an expert in that field. Let me bring in the top self-storage person onto my team as a consultant or somebody to help me do that. Or just, hey, this is a big deal. I'm used to doing 50 unit apartment building. This is a 200 unit, or maybe it's a portfolio. I need help. We can't all do it. I can't do all this on my own. I need somebody else to come in. That's how you do it properly. The challenge is that that's not what most people are doing. Most people are bringing the co-sponsors in primarily to raise capital because they need access to the capital. And then they're trying to mask it or trying to figure out, well, how do I now turn this person into somebody that's doing substantial duties? And I'm trying to force it in there, which if you can pull off, that's great. But you have to give them substantial duties. And what I've seen so far is whatever they're giving them, sometimes it rises to that level, but a lot of times I think it falls short. Showing up to Zoom meetings and not really participating in them, I wouldn't call that substantial. Now, if you're showing up to these Zoom meetings of the asset management with the property managements on a weekly basis, and you're adding value, and I pull the transcript and I can see that you're contributing to those conversations every week, that's helping the project, then maybe that's an argument. But the mere fact that you're showing up with 16 other people to a Zoom call, that you're not even on camera and you're just there and for attendance purposes, so again, it's very facts and circumstances thing. But you just have to make sure you can justify, and the burden is going to be on you. The burden is going to be on you to show that you did, or this person had substantial duties, which justifies whatever percentage of the GP they got. And again, the smaller the percentage of the GP, the less I would expect somebody to be doing. Like if you only own 2% of the GP or 5% of the GP, then maybe I'm just helping out with some underwriting, or I'm doing something small. If I brought in most of the money and I own 30% of the GP, you better be showing me something substantial that I'm doing. Otherwise, the government's going to argue that you were just brought in to bring in the capital.
Sure. Yeah. So I have this theory in my head. You're the perfect person to run this by, because if it's accurate, you'll know. And if it's not accurate, you'll certainly know. My theory is that the rubber meets the road on probably almost all this stuff, as far as getting in trouble and going to jail when you have unhappy LPs. Is that?
Well, that's 100%. Yeah.
80%, 90% of the time?
100%. I would say 99.99% of the time, unless it's one of these, even then, unless it's one of these things that are on their hot list, like, back in the day, maybe even now, maybe if you're doing crypto, or if you're investing in some country that's on the blacklist, and, something like that. But there's the SEC, and by the way, it's not even the SEC that I'd be mostly concerned about. I'd be more concerned about the state regulators, because those are really the folks that are probably going to come after you. So if you have an investor in Florida, then I'd be more worried about the Florida Securities Department than I would be of the SEC. Not to say I'm not worried about the SEC. I'm just more worried about that. But they're not on there.
That essentially you're essentially saying state level SEC, the SEC
state
of
regulator.
the state.
Yes,
Yeah.
Every state has their own Department of Securities or Department of Corporations that oversees their securities. They are, unless it's a huge deal, the SEC generally will focus more on Ponzi schemes and $100 million deals or whatever. So usually it's a state regulator that gets involved, but they're not actively on social media scouring the world to see that if you violated something, or it usually starts with a phone call from a complaint from an unhappy investor. I'll walk you through the process in really quickly, because I've gone through a few of these over the years. Obviously, I haven't done this 25 years. I think I've only done it about 6 or 7 times. But generally what happens is you have a disgruntled investors. They pick up the phone. They call the SEC. They probably get blown off by the SEC. Then they call their state regulator. And then the state regulator at that point is excited because they don't have much to do these days. So they will open up an audit, and they will send the sponsor a letter saying, they don't tell you who it complained or why they complained. They just say, hey, it's come to our attention that you've got this deal. It looks like whatever the allegation is, please send me all of your documentation, all of your PPM, your operating agreement, all your emails, all your notes, all the information that they can. There's literally like a list of 50 things they want for that deal. And I want to see every single of those documents for every single deal you've done in the past. So they want to see the history. So if you've done 17 syndications, they want to see the audit for the prior 17 deals. So that's how they open up the audit. And I think it depends on how you respond to that audit will dictate if that goes any further or not. My experience has been that once we send them a letter from us, from the attorney, identifying ourselves, hey, we're Securities Counsel, we did this deal, we complied with this exemption, that's why we didn't register it, and here are all the documentations with all of the signatures of the thing, and we just send them literally a PDF with. I used to do it with wet signatures, and I'd literally send them a list of, probably, I don't know, 600 pages of documents. Now it's all DocuSign, so it's all sent via a document. Usually when we send that back, that's where it ends, because a lot of times when people don't do it properly, they don't have an SEC attorney. When they ask for those documents, they don't really have much. They'll send them sort of the articles of organization and the EIN and a flimsy 2-page prospectus or whatever. That's when they're like, okay, this is easy. Usually when they have a securities attorney involved and all of these documents, they know they've crossed their T's and dotted their I's. They're usually like, they don't want to pick a fight because it's going to be an uphill battle. They're really looking for, in my opinion, my experience, they're looking for low-hanging fruit. Now, again, if there's flat out, none of my clients had ever done any sort of fraudulent, flat out defrauded someone, like a Ponzi scheme, or like I'm using investor money to go on my yacht, that might be a little different. But if you just like, hey, I just, maybe your disclosure wasn't the way it was supposed to be, or just the investor just complains, it's just an uphill battle for the regulators. But that's how they get involved in the beginning, is somebody picks up the phone or sends them an email and complains. And that's what opens up or triggers an audit.
We'll kind of round it out with this. And I mean, this is a great full circle kind of thing here, because just coming back to doing things right, CYA, staying out of jail, but also how to do that. And it really comes back to like doing right by your investors first and foremost, right? So when you see a disgruntled investor that picks up the phone and makes a call that leads to an audit, what are they usually unhappy about?
It's usually the returns. It's usually like, hey, you promised me. Well, first of all, I've yet to see, and again, I've only done, and again, just do the math, 200 deals times 25 years, but I've only dealt with about 6 or 7 of these issues, right? And in every case, it's been, there's just either the investor loses their money or distributions are just stopped. Hey, you promised me, they think it was a guaranteed 8% or 10%, and you lost all my money, or I lost half of my money. There's usually a loss of money. That's in my experience. Now, again, I have had some deals in the earlier days. I'll give you a quick story. In the earlier days, I don't do these anymore, but I would also review PPMs for passive investors to kind of see if that was, it was kosher for them. A lot of attorneys, when they start, will do that just for some extra income. And there were a couple of scenarios where either they didn't have a PPM, or it just seemed like they were cutting corners. And I was advising, hey, these are kind of red flags. And those did turn out to be sort of fraudulent stuff going on, like literally, loans from the company, putting a lien on the property for personal loans. I mean, some kind of egregious stuff like that. I think if it's a trigger based on some kind of fraud like that might go to the next level. But again, in my experience, it's only been when investors lose money. And again, these aren't guaranteed. In fact, our documents are very clear that there's no guarantees that any of these distributions are going to be made. There's a disclosure. You could lose all your money. In fact, you should only invest money that you're prepared to lose. It's an illiquid investment. I mean, we give them all the disclosures. So That's why it's an uphill battle for, I think, anybody trying to come after a syndicator if you've got the proper disclosures in there, because barring fraud or barring that you fail to disclose, which is a big one, right? It's like if you failed to disclose something and that led to the loss, well, that's going to be an issue. But that's why you want to have good securities counsel who knows all the questions to ask, so that they know what disclosures to put in the PPM, because a PPM in and of itself is kind of worthless. It's really, what are you putting into the PPM? And you got to make sure that all of the disclosures, the material disclosures, are in that document. And that usually comes from a grilling. I mean, we just grill you and we send you questionnaires and we get on phone calls and we pepper you with questions so that we can extract the information from you and know what to put into the PPM.
Yeah. Yeah. And again, just full circle back to, like, you need a specialist. You need not only a specialist, but a specialist with their finger on the pulse of exactly what's going on in real time in this space, in the law, and what the SEC is doing and what changes they may be making. And like, this is a big enough job that you cannot count on you getting this right, or an unqualified attorney or Chat GPT, right? So there'll probably be people taking that route at some point. But anyway, Mauricio, this has been amazing. I think the value points here, talking about just like staying out of trouble, but also like proactively doing things right. And the importance of that, the Corporate Transparency Act, guys, you got to be on that. And that's, I'm talking to me as much as anybody. Like, it's not something I've tackled yet. I know I've known I've had to for a while. And how to get paid to raise capital, how to do that right, and last but not least, like how to keep LPs, happy. And the reality is, like, things happen, right? I mean, a massive percentage of syndicators or syndicated deals that were originated over the last, say, 2 years are not paying prefs that they might have been projecting to pay, right? So you have to like prepare for an unhappy LP coming in and making a phone call, and you just got to be ready for that. So, and that's what Mauricio is here to help you do. So YouTube channel, Mauricio, the book, what's the website on the free book again?
Stayoutofjail.com. Just go to stayoutofjail.com, get a free copy of 5 Things Every Syndicator Must Know to Stay Out of Jail. I think LinkedIn is probably my preferred social media. I'm on there quite a bit. And then YouTube, like I said, I put out a ton of content out there. So if you're interested in the topic, and I would, if I've provided any value whatsoever, I'd appreciate a subscribe, trying to grow the channel and let other people find out about it.
Yeah. Again, if you're in this space, you got to have Mauricio's channel as a reference. The amount of diverse content there, you have to be referring to that. It's a massive library. Mauricio, awesome stuff, man. Really appreciate this. Appreciate you being on the show. Any final words for listeners? Keep your nose clean, right?
Keep your nose clean. And, the last thing for listeners, especially for my syndication folks that are listening, just communicate with your LPs. That's such a big issue right now. It's just communicate with your LPs. Even if things aren't going well, over communicate, keep those lines of communication open, and that'll help quite a bit in these rocky times.
So key. Hear that from everywhere, all across the industry. Thank you, Mauricio. Appreciate you, man. Thank you, listeners. Hope you got a ton of value out of this one and continue to get value out of all these. But this was a true guru episode, and love having to bring people like Mauricio to you guys and share his expertise. So we will see you on the next show. Take care, everybody.
This has been the Apartment Gurus with Tate Siemer. If you enjoyed this episode, be sure to subscribe and leave a rating and review on your favorite podcast platform. To contact Tate, go to www.investwithgreenlight.com for access to his investor portal and Calendly link. He loves to hear from you and thanks you for being a valued listener. Just a reminder that you are the guru. See you on the next episode of the Apartment Gurus.